Hi, I'm Debbie Moraes. This is Legal Matters, the program that's been designed to address relevant, critical, sometimes contentious issues that are facing consumers and businesses today. It's legal information, practical solutions, and as we say, straight talk about a wide variety of topics that will affect your home and your work life. We want to begin by thanking and also welcoming our Bazar Grasso law firm from East Providence, who continue to share and provide information and insights on all the topics that we cover. David, welcome.
Thank you,
Bazar
Debbie.
from the law firm. We miss Jackie. Hopefully she'll be back with us shortly. Today, we're going to discuss the process of workers' compensation cases. We've touched on it before, but many other specifics came up. We thought this would be a good time to flesh that out. So from filing to hearings to expediting the cases to what happens, what you need to know to protect the claim, and what you don't know apparently can hurt you. Those doctor's visits, the rejected or disputed claims, investigative agents that are monitoring you, even if you've been a good person and handled the case properly. When does David come in? I think this is a good time to backtrack and say we're not planning on not talking about anybody who games the system, someone who has a legitimate injury, a workers' comp situation, and they're reasonable. So from the time it happens, when do you come in and go through the case, if you will, and share a couple of anecdotes if you can?
So there's a lot of information that we can share, but maybe we should start with the history of workers' compensation.
Okay.
And because it shapes what the benefits are and what you can receive and not receive in a workers' compensation claim. All right?
Okay.
So, Industrial Revolution, we have factories springing up and people getting hurt at work. Before there was a workers' compensation system, you had the common law remedy of a personal injury case, which meant many years perhaps in court fighting for your rights. If you got hurt as a result of your own negligence, you couldn't recover. So now we have a person who's out of the workforce and can't provide for their family and has a bunch of financial pressure on them. So a system was developed, the workers' compensation system, to provide for people who get hurt at work. So the first key in a workers' compensation case, and this history can take us through a little bit of how it works today, is that the injury has to arise in the course of your employment. So if you're hurt at work and you can no longer do your job, you're now able to recover your lost wages, a percentage of your lost wages. At one time it was 2/3 of your lost wages. Now we have a complicated formula based on spendable gross income, and you get a percentage of that. So all you get for workers' comp on the initial thing is your lost wages, a percentage, and your medical bills. You gave up your right in exchange for this system, the right to sue for personal injury, pain and suffering, that type of thing.
Now, if that's the case, then I understand that there's a wide swath that cuts from what gets covered, what's inside and what's outside the scope of work. And apparently there's so much minutia that we could never cover it, but maybe you don't get covered when you're commuting to work, but if you're a salesperson and you're making a call and something else happens on the road. I mean, it seems like there are a lot of ins and outs that make it very difficult for you at times to know clearly this is workers' compensation and pay me.
So, a lot of interesting things that you raised there. So, as we talked a little bit about the history of workers' comp, you gave up rights for that pain and suffering and these other things in exchange for being covered for injuries that arose out of the workplace, and you did not have to prove negligence against somebody in order to recover. What you did need to prove is that you were hurt at work. So you mentioned the going and coming rule, so to speak. Were you at work at the time? You're on your way to work. Were you close enough to work in order to become a workers' compensation case when the accident occurred? So there's lots of case law on these things. A company that has a parking lot across the street from the business, you've already arrived, you parked in the parking lot, you're walking across the street to get into the building, to punch in, you get hurt. Have you gone far enough along to get yourself into the workplace to be covered? These are some factual issues, legal issues that raise really fascinating issues. And it's really factual and a case-by-case basis, and based on what your job duties are, what your responsibilities are, what you have to do in order to further the business of your employer.
I hope we get to continue on that, because while I want to go through what the cases are about. Apparently, even what we talked about at one other time about small businesses and independent contractors and people who perhaps had some pre-existing conditions, there's so many caveats here that complicate these. I don't know how many of these we can get through, David, but take us through some of these cases.
Let's get through all of them. We'll get through all of them.
Take us through some of these cases. How do you start this? How do you start the process?
All right, let's first assume you got hurt and that it was at work. And let's make it an easy case. You were working, perhaps you work in a factory and a machine catches your hand, which raises a whole bunch of other possibilities, and now you're taken from work to a medical facility for treatment. Clearly you were hurt at work, you were doing the business of your employer, so now you have to file a workers' compensation claim, and that can start with just the business bringing you to the medical for treatment, and now your employers know, your supervisor, someone needs to know, and the case begins. So let's just go back one step. Even if you were hurt as a result of your own negligence, you know, you were working on a machine and you were going too fast and you knew you were going fast trying to keep up, but you put your hand in harm's way, so to speak, you can still get workers' compensation. I told you it raised a whole host of other things because if there was a machine in there that malfunctioned that was as a result of a products liability case, you could perhaps also have a third-party case, which is a case against somebody else for their negligence. And so that is an overlay on top of your workers' compensation case. I know we're here to talk about the workers' compensation case, but these other things are very interesting components of that case.
Interesting that you bring that up, because for as much as you would imagine the average worker doesn't know the ins and outs of a workers' compensation case and when they should be contacting or if they should contact a lawyer versus having the employer take care of it, what you bring up is that could be much more going on that they couldn't possibly know, much deeper and wider in scope. You have a very good point.
Absolutely. And so here's the thing. Let's just get that question answered out of the box here. When should you call your attorney, an attorney? You should call an attorney, such as my office or any other office that does workers' compensation cases, because it is a specialty area, and you should do that right away, because you do not pay the attorney out of pocket on these cases. The insurance company that provides the workers' compensation insurance pays our fees up until the time we can talk about it if there's a lump sum or a commutation of the case where you're going to get a lump sum of money and then you pay the attorney a percentage, 20% out of that settlement.
Address something. If someone is injured at work and they go to a doctor, I know it varies state to state, and I'm not asking you to speak to all states at the moment, but I understand that there's some time frame within which you have to both report it to the employer if he didn't know about it right away, and also you have to be somewhat careful about what doctor that you end up seeing. Wouldn't you think that if you have your own choice of doctor that made sense, but apparently, please help our listeners or viewers know what happens when sometimes the workers' compensation insurance company who says you'll have to go to see our doctor.
Okay, let's talk about the medical then. You go to the medical facility for emergency treatment from your place of work. They know, but you should make sure that a formal report is given to your supervisor as soon as you're able to. Obviously, medical treatment first. Then you get to pick your main treating doctor. So let's suppose it's an orthopedic situation. You should pick the finest orthopedic doctor you can get that can treat you for this case. If it's a hand injury, you should find a hand specialist. If it's a knee injury, a knee specialist, whatever it is. And you should pick your doctor, who is the finest doctor you can get. Now, during the course of your treatment, during the course of your disability, the insurance company is going to be paying your medical bills, but they want to get you off workers' comp as quickly as they can.
Certainly.
So they will send you for an IME. That might be phrased in some corners as an independent medical exam. I would call it an insurance medical exam because they're sending you to a doctor that they've hired to evaluate you. And many of these doctors are good, but some of these doctors are out there just to do one thing, say that you're fine.
There's a bias there.
There is a bias, and you've got to understand there's a bias because they're hired by the insurance company to examine you. They're hired by the insurance company who they know is paying you workers' comp, and the insurance company wants you off as soon as they can get you off. So now if the insurance company files a petition to stop your benefits, and your doctor says you're still disabled, and the insurance medical doctor exam says you're not disabled, the court can appoint an impartial doctor to examine you.
A third doctor.
A third
second,
doctor.
Whatever. Okay.
Right. So one of the downfalls of workers' compensation, if you will, is you will be seeing lots of different doctors. Your doctor, the insurance company doctor, perhaps an impartial doctor appointed by the workers' compensation court.
So while you're talking about things medical, I don't want to go off on a tangent here, but suppose you'd been seeing an orthopedic person before because you had arthritis in your knee and something happens at work and in fact your knee becomes part of that injury. Do you go to see that doctor again? Someone's going to say you had a pre-existing condition, you didn't hurt yourself at my workplace and you aren't entitled to workers' compensation. What do you do in that case?
Well, let's assume that you have a pre-existing arthritic condition and you're at work and there's an incident and that incident causes you to be unable to now perform the duties of your job. Your regular doctor is fine as long as he's a doctor that's used to dealing with workers' compensation cases, and it's actually probably pretty good to go to a doctor that's already seen you because he can compare your condition before the incident to after the incident.
Okay.
And many times you'll have a situation where there may have been a pre-existing condition, but you were able to work despite that condition, and now the accidents cause that incident to rise to a level where it's disabling, and if that's the case, then it is a legitimate workers' compensation claim and you're entitled to the benefits.
Good to know. Important to know.
Right.
Okay, so where else were we with the start of this processing of the case? Obviously first was the medical side of it.
Right.
Take care of yourself,
So-
make sure you're out of harm's way.
That's correct. And then the next part of it's the legal part, perhaps, and you should hire an attorney because there's lots of things an insurance company can do to perhaps not provide all the benefits you're entitled to. One of the things is how do they pay you and under what legal document do they pay you? They could be paying you under what's called a non-pred. That's a non-prejudicial agreement, which means we're going to pay you for a period of time, but we're not necessarily saying this is a workers' compensation case. We're just accepting the fact that we're going to have to pay you for a period of time. And if they pay you for that period of time and then stop before the non-pred period runs out, then there's no legal document that you can say, wait, you have to continue paying me. And you would be forced to go to workers' compensation court, perhaps with a break in payments until you get heard. And that's one of the things they can do. You want to be paid under what's called a memorandum of agreement, which is a document that's filed with the Department of Labor, which states this is your injury, this is what your average weekly wage is, which is what's the basis for your compensation benefit rate, and make sure that all of that's correct and filed correctly so that they have to go to court to stop paying you.
Now, would you be filing that MOA, or if you were approached as
the attorney?
Yes.
So a client comes to us. What we would do is we would check with the Department of Labor to see if it has been filed, and then if it's not filed, we would file what's called an original petition with the Workers' Compensation Court. We can't file the memorandum agreement. The insurance company has to file it.
Okay.
So we would file this document, the original petition, to have the court determine what the injuries are. And if a memorandum of agreement is filed, we'd look at it and suppose it just had your elbow, when we know your whole arm or your shoulder or other body parts belong on that, we'd file to have those added to it. Or if the average weekly wage was calculated incorrectly, we'd file to correct that. So oftentimes people will come to us being paid incorrectly or for the wrong body parts, and we'll file to have an original petition to correct those things.
Is that considered what preparing for trial is about, or is that just about circumventing or bypassing an insurance company that wants to say, let's settle right now and wrap this up?
Well, an original petition is filed to establish the injury in court for the first time. Anything filed in workers' comp is done with a pre-trial first and then potentially a trial. So it's very possible that you would need at some point to go to trial on cases because there's so many intricacies to a workers' compensation case. The arising out of and in the course of your employment issue. So is it a workers' compensation case? Often the medical, is it disabling to the point where you can't do your job, and there's controversy in medical conditions based on the insurance doctor, your doctor, the impartial. So there's a myriad of things that can come up. Where does the case belong? You're working for a Rhode Island company but injured in Massachusetts. Is it a Massachusetts workers' compensation case or a Rhode Island case? Oftentimes it depends where you were hired. So And they raise different issues because different states have different rules for workers' comp and how they administer your benefits.
Okay, so continue with us. Now, you're in the process of preparing for trial. We don't know whether something's going to go to trial. What other steps continue along the way before you get to trial, no trial, mediation, whatever else
Right.
you're going to do? How else goes
You
on?
love trials. So what happens in workers' comp is most of the cases go to pre-trial first, all of them, and you meet with the judge, you present your case, the other side presents its case. The judge can make a ruling based on what's presented, and then either side can appeal for a trial. And then if you get to that point, now you're talking about depositions of doctors. If it's a medical issue, you may be talking about deposition of co-employees or people at work that saw the accident or have information about the accident. It depends on what the issue is, but that's something that an attorney can prepare and be ready for, and someone who does workers' comp, we do this all the time.
If it's pre-trial stages, does that harmed, injured person, do they have to show up, or do you just go to court with the
Your client
fact-
needs to
they
go
both
with you.
need to
There may
go.
be questions that the judge might have of the client. There may be other issues that you want to ask your client that you thought you knew, but there might be a nuance to it that you need to know, so they should be there. When I go to court on any case, I always want my client there. I want my client to know that we're doing something. I want my client to know what we're doing, and I want my client to be part of that process.
And do you have any control at all over how to expedite the either settling or the trial of that case?
Well, you cannot force anyone to settle in a workers' compensation case.
Okay.
So there's no control over that. But what you do have control over is filing of petitions, and the workers' compensation court is set up for expediency. And when I say that, it's going back to that history that I laid out at the beginning. You don't want an injured employee who's under financial pressure to go a long period of time without any income. So if you have a workers' compensation case and they haven't agreed to pay and you file, the process is not like a trial in other courts that there's a lot of discovery go on for years. You get that pretrial very quickly, and you get a hearing pretty quickly after that.
And thinking about how quickly means, could it be 30 days, 60 days, it could be several months. How does that track along with someone's undetermined rate of progress of their case, their medical case? It might take them a very long time to heal. We don't know exactly how far they have healed, will heal, whether or not they can go back to work. How do you get to gauge whether this is better for your client to have this go on a little bit longer, because actually it may show that he may be permanently disabled and so on?
Well, what happens is if you're disabled for doing your job, the first thing you need to do is either have that memorandum of agreement in place or file the original petition, because once the injury is established and you're being paid, the insurance company has to pay you until there's a court order saying they no longer have to pay you. So no matter how long you're treating for, no matter how long it takes you to get better, you're going to get paid. Now, there's a difference between total disability and partial disability, because there is a limit on a number of years that you're going to get paid partial disability. And after 6 years, if you haven't gone through what they call the gate, which is to prove that there's no jobs that you can really do out there, they could stop your benefits. So it's really important to know how you're getting paid initially, because let's suppose you had an injury and it required surgery. And there's a period of time when you're having the surgery and following that you couldn't do anything. So you should be paid total disability benefits, which not only perhaps based on dependencies and other things may pay you more money, but doesn't stop the clock running against how long you're going to be paid for.
Okay. Address, if you will, how the element of mediation comes into play, when it might and when it wouldn't. Is it a matter of the size of the case, just smaller cases would be mediated rather than going on for a protracted period of time and getting everybody involved? No?
Mediation's not a big player in workers' compensation cases.
At least locally? Some places it seems that it is, some states, so you
It
think
may
not.
be, but
Okay.
not in Rhode Island.
Good to know.
In Rhode Island, there may be mediation. I had a case, you wanted examples of cases, where there were other components to the case. And as I mentioned to you before, there could be a third-party case, which is where there's somebody who's responsible for your injury that's not a co-employee, who therefore could be liable to you for negligence, for personal injury. And you can file a negligence claim, and the workers' compensation insurance company is going to be reimbursed for whatever they paid out, because you're going to collect your entire damages, including pain and suffering, back. And so if that case goes to mediation, you might want the adjuster for the workers' compensation case involved in the mediation in terms of their subrogation, the payment back to them, because you may need some negotiation on that.
Good to know. Okay. What about actually settling a case? Does that element come into play right up through the idea of there being a trial? When does that come on the table? When do you put that on the table?
Okay, so if you have somebody who is going to be out of work for some significant period of time, or could never do their own job again, but would like to get back to doing something else constructive, that you start talking to the insurance company and you make a proposal for settlement in a lump sum or a commutation of your benefits. And you would calculate out what the benefits you're receiving are and what period of time, how many years you might get those for, and start negotiating with the insurance company to commute or settle those benefits. In Rhode Island, when you settle your benefits, for the most part, you're settling both the number of years that you might have for payments, for benefits. You also could be settling loss of use or disfigurement, which are two other components that you're entitled to receive in a workers' compensation case, and medical bills, perhaps. In Massachusetts, medical bills are left open. In Rhode Island, they can be closed out, usually are. So when that happens, you're negotiating a settlement. But like I said at the beginning, you, as the injured person, do not have to settle, and the insurance company does not have to settle.
You're a lawyer. You're not a tax accountant or an accountant. Do you usually need to bring someone in that's on the financial side to determine or weigh what the value is to your client, or whether or not there's benefit in him taking a lump sum versus over a period of 17 years or whatever? How does that come into play?
We don't have to do that.
Okay.
That's something that we know the value of the case. The client knows his needs and what he can and cannot do. The insurance company knows what they may or may not pay out. So all of those things factor into how you reach a settlement. From a tax perspective, a personal injury case, workers' comp, they're not taxable events for income tax purposes. For your client's perspective, what you're going to receive in a lump sum in what he needs is more part and parcel of his own living style and what his disability is and what he or she is able to do, as opposed to what's the tax consequence.
Okay, good to know. And address, if you will, the idea that someone could actually have been rejected, denied benefits, or just need to appeal. When does that happen, and what do you do about it?
So that's, if you're talking about out of the box, out of the gate.
Disputed claim from the beginning?
Yeah, so that's part of that original petition where you have to establish the injury, that the injury was as a result of your work arising out of the course of your employment, and that it's medically disabling for the duties of your job.
So if you're a lawyer on the case, so to speak, and someone says, the insurance company says, we're denying the benefits or we're cutting back or whatever, because someone had, say, that arthritic knee, or someone had some problem with their hand and now they're saying it's carpal tunnel and they're injured and can never go back and do their work, do you get involved in having to go back and not recreate, but get that history? Is that part of what you need to do for expert witnesses and have the doctors and orthopedics and surgeons and so on to help offset what they're saying if they're denying claims or cutting those claims? Or
Sure.
Trying to?
That's a critical part of the case in establishing the case. So we've had cases where somebody slipped and fell at work and nobody saw how it happened. Nobody knows whether there was something on the floor that caused the person to slip and fall, which clearly would be a workers' compensation case, or if the person just fell as a result of some idiopathic thing happening, such as the knee gave out, back gave out, or in this case the person had brain damage, and was there something like a stroke or something that happened first. So we have to go back and recreate all those things for our original petition and give all the medical evidence to a doctor to take a look at the history of the guy before the accident, never had a history of slipping and falling or anything giving out, never had a stroke or anything. So was the brain injury more like a stroke victim or more like someone who banged his head falling on something? So all those things go in it. Many times a case like that where there's a large amount of damages and interesting legal issues in terms of how it happened and what you can prove might be D&D, which means denied and dismissed, which is you'll settle the case, in that case for a substantial amount of money, based on the projected damages and the benefits that you would receive, and therefore the risk to the insurance company and the likelihood that you can prove your entire case to the court. So if there's a risk that you couldn't and you can get your client some money, the money's paid on a denial and dismiss basis, which means we're paying you the money, we're not admitting, we're denying the liability, and based on the payment, the case is being dismissed.
Okay. In recent segments, we've talked to small business owners and talked about small business. Many small businesses don't have employees or many employees, but they do hire outside contractors, independent contractors. What do you do when it comes to having an independent freelancer who had a problem with something while he was at your site?
Okay.
Do they have a case, or are independent contractors not?
So workers' compensation
covered?
is a very important area for the distinction between an employee and an independent contractor. And sometimes that's one of the issues that's being tried in a workers' compensation case. If somebody is truly an independent contractor, 1099, makes their own hours, uses their own tools, controls what they do. So for instance, if you're in property management business, and you hire an electrician to come in to do work, and that electrician gets hurt while he's doing work at one of the buildings you own or manage, then that's probably an independent contractor, and you do not have a responsibility for workers' compensation for that person. But if that's someone that you're paying on your payroll, or they come in and work for you regularly and use your tools when they come in, and you tell them when they have to be there and when they can leave, even though you may call that person an independent contractor, it's probably an employee that you owe workers' compensation coverage to.
Okay. In the couple of minutes that we have left, what do you do about employers who we hear you shouldn't complain to, much less claim that there's a workers' compensation case, because then you might have your hours reduced later on or some sort of backlash? What do you do about that? Often difficult to prove. How do you handle that when you have someone you're representing?
Right. So there's a couple of things that you need to know. First of all, if you're injured, you're entitled to your workers' compensation benefits. There's insurance that's supposed to be in place for those benefits. And if you've been an employee of a company for a period of time and you're a good employee, they need to understand that your medical condition needs to come first. So if it's a situation where you might be able to get back to work after a short period of time and they then try to say, no, you're not coming back, there is in the law a right to reinstatement. It's not easy to enforce, and it's difficult and very rarely done, but that is out there. And the other thing is, if you have a good employer, they need to be able to, and I've had many cases where the employer is more upset than my client as to what the insurance company is giving them for benefits, because they paid for the premiums and they want their employees protected.
But realistically, David, if someone has workers' compensation claims, that does impact negatively on the employer. He has to pay more for his workers' comp benefits later on.
Perhaps that's the case.
Perhaps. Not always true?
Well, it depends on what kind of claim it is and
Okay.
how big the policy is, how many employees you have. So it can be, but the premiums are really much less in cost to the employer than the benefits that are needed by the employee. They mean much more to the employee than usually the employer.
Good point. We've covered plenty. We appreciate your tuning in. We invite you to stay with us as our discussion of legal matters continues.